number 1. Effectively.
All
matters related to not a 95.9, but deemed conversion.
Mic, the mic is on. Yes.
Not all these matters are covered by lordship judgment. The matter pertaining to not the section 95.9 of Karnataka Land Revenue Act. In all these matters, not petitioners have moved an application for seeking grant of quarrying license. Not applications not kept pending for want of deemed NA. Not an application is also filed before not a deputy commissioner under section 95.9. Not which application is kept pending till date. Therefore, before lordship seeking writ of mandamus and in several critical circumstances.
Yes. What do you say?
It is covered.
Judgment have you annexed?
Yes. Next.
Same order as that of page number 49, WP 3660 of 22.
49.
Yes.
The same order is to be passed.
Yes. The only difference is in the first application dated 3/3/2022, and in the place of crusher license
5/3/22.
3/3/22.
This first case application date in the prayer you see 5/3. 5/3.
Should have 5.
And in the place of crusher license, here it is quarry license.
Quarry.
The next page. E. Under E. For the purpose of stone crushing only, instead of that, quarry license only.
Do you have extra copy of this order? Just make correction by pencil in this which is to be changed. In this order dated 22nd of February 2022, page 49. We will pass this order, same order. Make the necessary changes, whatever is required. Date and all that. Have you understood or not?
Please.
Give copy to. Same order, page 49. Huh? This will pass the same order. You see what a correction you are telling that.
Crusher, and I have to mention that quarry.
All are same.
All are same.
1 to 5.
All are not crusher purpose, and all are for
Only application date differs.
application date is different. Number 6.
There are 12 office objections remain. 12 office objections are.
Interim order, there have been certain subsequent developments also.
Some office objections. First comply, only then we can hear.
Matter is posted before the learned single judge also.
What
Regarding
can-
confirmation. The sale note,
We cannot hear a defective petition.
PLR. 2 days time, there's some urgency. If your lordship gives us 2 days time, we'll comply with it.
The net counsel for the petitioner appellant prays for is allowed 2 days time to make good the office objections list on Thursday.
Second, you
There is not press for confirmation, then cannot say.
Number 7.
Come to the writ court order.
guardians and guards.
This is contempt arising out of which order?
Order passed by the Family Code, 4th Additional Principal Family Code, Judge, my lord.
Section
At
10?
page 28, my lord. You have
Page?
28, my lord.
Page 28.
Yes, ma'am. The petitioner is entitled for interim custody of the child master yard, 50% of first half of summer Dasara winter vacations. In view of COVID-19 pandemic, this order will be with effect from the academic year 22-23. The petitioner is entitled for visitation right on every alternative weekend of the month, that is from 6 p.m. to Saturday till 5 p.m. on Sunday. He shall pick up the child from the residence of the respondent and shall drop back the child to the residence of the respondent, that is 6 p.m. on Saturday, and drop at 5 p.m. on Sunday to the residence of the respondent with prior intimation to each other. The petitioner is entitled for contact right, that is, he can speak with the child every day over phone, through Skype or through video conference for 5 to 10 minutes in the evening between 6 p.m. to 7 p.m. and on Sunday for 1 hour from 11 a.m. to 12 noon with prior intimation. During the visitation, right, the other things. When the complainant tried to exercise his rights, the respondent, the accused, did not allow him to even have contact through Skype or video or take him to his residence. And the objection that they raised is that because in view of COVID-19 pandemic, this order will be with effect from the academic year 22-23. Then an application was filed. At page 31, your lordship gets it. The petitioner has filed IA number 7 under section 151 of CPC seeking clarification of order.
All right, all right. Issue notice. Respondent to show cause as to why contempt proceedings shall not be initiated for non-compliance. Deliberate of court's order such and such. The PF shall be filed within 1 week. List after service.
Number 8, Venugopal MS.
I wait for complaint. Direction is at page 24.
Order of annexing is being confirmed after
Yes. What was the direction?
Direction is at page 24.
Yes. Kindly read.
Paragraph 6. In view of the above and following decisions rendered in the aforesaid cases, these writ petitions are allowed. Impugned endorsements are set aside. The Deputy Commissioner is directed to collect the price at the rate of 300 times of the land revenue payable per acre that was prevailing as on the date of grant, and issue grant certificate in favor of petitioners within a period of 3 months from the date of receipt of the copy of this order. Against which, my lords, a writ appeal is came to be filed by the respondents, which came to be dismissed on 12th July 2021. Annexure C is the order in the writ appeal. Page 29. Thereafter, my lords, I requested the respondents by issuing a representation, Annexure D, my lords, 18/8/2021. And later, my lords, it appears they have approached the Honorable Supreme Court. SLP is also dismissed. I have produced Annexure E.
Thereafter, have you sent them any notice? No.
After writ appeal, I have sent the notice.
Where is that?
Annexure D, my lords.
Page?
Page 41. English translation is at page 42.
This SLP was filed by them.
No, my lords.
SLP who had filed?
SLP is filed by the state. SLP is in limine dismissed. No notice was issued anyway.
Third, if you notice, respondent to show cause as to why contempt proceedings shall not be initiated against them for willful non-compliance of the edit court order such and such, passed in jurisdiction such and such. PF within 1 week, list after service.
Number 9, Subramania Bhatt. So there was a direction to the accused to reinstate the complainant not within a period of 2 weeks. Kindly have a look at the operative portion of the order at page 27. Paragraph, my lord. Petitioner Messrs. Canara
Page?
Page 27, my lord. The order dated 7/2/2022. Lord,
Yes.
this order starts from page 25. Then the operative portion is at page 27.
Yes, kindly read.
Petitioner Mr. Canara Lighting Industries Private Limited, Airport Road, Mangalore is directed to reinstate the respondent into service within 2 weeks from the date of receipt of a copy of this order. Lord, after this order, Lord, immediately I submitted a representation on 10/2/2022, Annexure D, page 28. Lord, I requested the management to permit me to communicate a date for reporting to duty. Lord, then, my lord, after 2 months, I received a reply from the management as per Annexure E, page 30, where, my lord, I have been, blame is put on me, stating that, my lord, I did not come and report to duty. Very next time, my lord, I submit this representation.
Third, you should notice to respondent to show cause as to why contempt proceedings shall not be initiated against him for willful non-compliance of the court's order dated such and such, passed in expedition such and such. The PF shall be filed within 1 week, list after service.
Next matter, bill number 10, Mr. Nagaraj D.
Representative for the respondent, accused may not, we have reinstated him.
Huh?
We have reinstated him, we are supposed to reinstate him. As you lost directed, my lord, we have reinstated, my lord, it appears, I am told, my lord, he has also reported to you.
I have reported on 27th, my lord. 25th, they have passed the order.
You have joined at Mysore.
I have joined. Make me one submission, my lord. On 11th November, my lord, directive was issued. On 22nd December, my lord, they have, instead of reinstating me, they have relieved me. From 22nd December to till today, my lord, for their fault, my lord, I have deprived my livelihood. That has to be compensated, my lord. For no fault of mine, my lord. For their pay salary to me, Lord, for 4 months.
Cannot issue any direction in contempt proceedings.
True, Lord, but delay compliance, Lord, may not be considered.
Initiate proper proceeding before the appropriate forum.
The liberty may be reserved.
Huh?
Liberty may be reserved, Lord.
Liberty? What liberty? No
Otherwise,
liberty is required. We will only dispose of this petition, and we will say that in case you have any grievance left, you may approach the appropriate. This contempt petition arises out of the order dated 11/11/2021, passed in WP 5497/2021 in bracket S-RES bracket close, whereby a positive direction was issued to the respondent oblique accused to reinstate the petitioner complainant with 50% back wages after quashing the order, after quashing the order of dismissal dated 10/7/2022. Learned counsel for the complainant petitioner submits that instead of passing the order of reinstatement, the petitioner had been relieved and directed to join at Raipur. The petitioner complainant had challenged this order by filing another writ petition WP 728/2022, in which the operative portion of the relieving order has been stayed, wide order dated 4/2/2022. In spite of the same, the petitioner complainant has not been allowed to join at a place where he was working at the time of dismissal order. At the time of passing of dismissal order. The court, wide order dated 25/5/2022, had permitted Mr. Chandrakant R. Ghole, learned counsel appearing for respondent, to take instructions and the case was adjourned on his request after being informed by Mr. Chandrakant R. Ghole that the respondent accused would pass necessary orders for allowing the petitioner oblique complainant to join at Mysuru. Full stop. Today, when the case is taken up, Mr. Chandrakant R. Ghole, on the basis of instructions. Do you have the copy of the order? Have you filed any compliance? Has filed the memo of compliance.
About the 25th, same day.
Along with copy of order dated 25th May 2022, whereby the petitioner complainant has been permitted to report duty on the post of assistant division, on the post of second division assistant in the office of Mysore Medical College and Research Institute, Mysuru. Full stop. In view of above,
I have reported on 27th.
Learned counsel for petitioner submits that he has reported for on duty on 27th. In view of above, we are satisfied that the order passed by the writ court has been complied contempt petition is accordingly dismissed, notice is discharged. In case petitioner is left with any other grievance, he is at liberty to approach the appropriate forum. Then, order compliance with dismissal.
Number 11, Vishwanath Shetty.
How they have served coffee just I'm coming to know.
Eh?
There are 3 updates.
Order is complied.
Dot is passed.
All right, what was the direction?
Direction, my lord, will get at page number
15.
Please, my lord.
Correct. 3.
Operative portion, page number 15.
In view of these facts, the concerned committee is hereby directed to decide petitioner's grievance within a period of 3 months.
Please.
Now, where is the compliance? Give.
Paragraph 3 of the affidavit. my lord.
Learned AGA appearing for respondent
Please.
has filed the affidavit of compliance. Compliance with the same is taken on record.
Paragraph 3 of the.
In paragraph 3 of the compliance affidavit, it is submitted.
Only 4 and 5 is considered and others are not.
Claim of components 1, 2, 3, and 6 are rejected. 4 and 5 is by order dated 18/4/22.
This application for regularization has been rejected.
Please, my lord. So far as in respect of components 1, 2, 3, and 6,
Only 4 and
4 and 5, they are allowed.
The as Kelly, what you read? That the application of the complainant for regularization on behalf of complainant number 1, 2, 3, and 6 has been rejected by the committee in its meeting dated 18/4/2022. Stop the application for regularization of complainant 4 and 5 has been allowed.
Please.
Full stop. The decision of the regularization committee dated 18/4/2022 has also been brought on record. In view of above, we are satisfied that the respondent have complied the direction issued by the writ court by the order dated such and such, past the date petition such and such. However, in case petitioner is aggrieved by the decision of the regularization committee dated 18/4/2022, he is at liberty to challenge the same before the appropriate forum. The contempt petition is dismissed. Notice is discharged.
Number 12, to Vijay Kumar.
Accused number 1, my lord.
Counter affidavit filed by my learned friend. I wish to file counter to this plot. The calculations which the university have provided plots is incorrect. I will also furnish the calculations as per my direction. What I want to file counter to the affidavit which my learned friend has made. The calculations which
No, they have passed the order in compliance of writ court directions.
The amount is paid, my lords. as per the
Whatever
direction.
they found it, they have paid. Now, if you are aggrieved, you will have to challenge that order. In contempt, we can't do anything.
I agree, lords. I will furnish the calculations, lords, which they have wrongly calculated and punished. 1 week time may be granted notes. In the meantime, notes I'll file my
Where is that compliance order?
Notes are filed a counter affidavit. Along with that, my lord, sir, endorsement is
All
also.
right, all right. Let's see first what is the direction. Respondent state government is directed to pay 20% of arrears of salary in cash
Yes,
consequent upon the revision of pay to the petitioner if not
My lord, sir,
already
that's
paid.
not the order. My lord,
The
sir. Order
remaining
is-
amount of 80% shall be invested in NSC
yes,
8 issue in multiple. The petitioner
number.
Sorry to
so
interrupt,
far
my
as
lord.
it relates
That's not the order, my lord, sir. That's not the order. Order is at page number 19, my lord, sir.
18 and
19
Please, my lord, sir, 19, please.
19.
Direction is at page number 19, my lord, sir. This was the direction.
rate is
C, my
allowed.
lord, sir. Clause C, my lord, sir. Page 19. C, my lord, sir.
Constitution of
Entitled to same rate of interest from time to time on
the
18.
petitioner shall be entitled to the same rate of interest from to time on 80% of his arrears of salary amount if it would have been invested in SC to the date of its maturity and further.
Pursued, my lords, to see the para number 7, my lords, previous page, page 17. Para 7, please.
7 of
7 of this order, my lords. Page 17, my lords. Previous page, my lords. Lords will get it at para 7. Lords, there is a mention of the amount which was paid during the pendency, my lords. That is 72,627, my lords. Direction was to pay the interest on this as if it is invested on in the NSC.
Which I
And
have not done.
further 8% interest. I filed I do the calculation, the counter affidavit, even the endorsement, my lords.
now you say that this is wrong.
Yes, sir. I'll file the calculation for
But please try to understand. You say that this is wrong. Calculation. Whether in the contempt proceeding can we decide what is right, what is wrong. Please answer to the query. Can in the contempt proceedings court direct what is the right amount to be paid? There is no willful disobedience or non-compliance. They have complied. Whatever they felt, that is the compliance that they have done it. Now, if you are not satisfied, go and challenge it. It cannot be termed to be a willful non-compliance or disobedience.
one more round of litigation. That's what I wanted to avoid.
It is not possible for the contempt board to decide. Or this contempt petition arises out of order such and such, past delivered petition such and such, as per the direction issued by the writ court. Certain interest accrued from time to time on the 80% of arrears of salary which was directed to be invested in NSC 8 with NSC-Roman 8 with effect from year 2005 up to date of its maturity and further interest at 8% per annum from the date of which the said amount invested in NSC 8 was directed to be paid. Para. Counter affidavit has been filed by the respondents. Learned counsel for the respondent submits that the direction issued by the writ court has been fully complied and in compliance of the same areas of interest has been calculated and paid. The details of the amount paid along with its date has been given in paragraph 4 of the counter affidavit. It is submitted that the order of the writ court has been fully complied. We have considered the submissions made by our counsel for the complainant as well as respondent and gone through the record. Prima facie, we find that the direction issued by the writ court has been complied, and as such we are of the view that there is no willful non-compliance of the order passed by writ court on the part of the respondents. The contempt proceedings are accordingly dismissed. Notices discharged. However, in case petitioner is not satisfied with the compliance, he is at liberty to challenge the annexure R1 dated 9/5/2022, which is annexed with the counter affidavit of the respondents. Yes.
Was allowed given direction to consider representation within 4 weeks, my lord. They are not
Come to the relevant paragraph.
Page number 13, my lord.
14.
Para number
Eh?
7.
What can only be considered?
Prayer B and C, respondent number 4 is directed to consider the
Representation.
In accordance with within a period of 4 weeks from the date of receipt of certified copy of this order.
Your representation has not been decided.
Not been decided.
When did you communicate the order?
Communicated on 27/10/2021.
Where is that?
Annexure B, my lord.
Eh?
Annexure B.
Order got reference. Had you annexed a copy of the order?
Annexed with copy of the order.
Kindly show from this annexure B.
Last pair. ಅದರಿಂದ ನಾನು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮೊರೆ ಹೋಗಿದ್ದು ನ್ಯಾಯಾಲಯ not filed.
Disclose the date of the order passed in writ petition such and such. All orders which have been mentioned. That is all.
Annexure B I mentioned, my lord.
Kindly.
Annexure B last pair. ಅದರಿಂದ ನಾನು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಮೊರೆ ಹೋಗಿದ್ದು ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 22/9/2021 ನನ್ನ ಪರವಾಗಿ 4 ವಾರಗಳಲ್ಲಿ ಪಹಣಿ ಹಾಗೂ ಖಾತೆ ಮಾಡಬೇಕೆಂದು ಆದೇಶಿಸಿರುತ್ತದೆ. Writ petition ಸಂಖ್ಯೆ ಸದರಿ ಜಮೀನ್.
All right. In which paragraph you have said that they have not decided your representation? It is still pending. What is it?
Para 4, my lord, in my page number 7. Para 4 and 5 stated, my lord.
You not said that representation is not decided. You have only said, in spite of this said representation such and such, the accused has not acted upon.
Yes, my lord. Not pass the orders, my lord, not the issue notice.
Where you have said? Not passed any order, representation not decided, it is pending. If your representation is rejected, they were not supposed to act upon.
But there is no communication to me, my lord, after giving.
To fail to comply with direction issued by the, which is clear contempt. How they have failed? You have to be very specific in contempt proceedings. If the direction is to decide the representation and your representation has not been decided,
Yes, my lord.
then you will have to say so.
Stated only, my lord, regard detail and not.
File the supplementary, we can have the matter again day after tomorrow. Say specifically that by this order, direction was issued to decide representation by so and so. You have communicated this order on this date. He has full knowledge, but in spite of that, he has willfully not complied the order and as such has not decided the representation. You will have to be very specific.
Next.
Not acted upon, failed to comply. All these words can only be appreciated when you say that he has not decided the representation.
1 week, my lord. She's
1 week.
1 week. She's
When
a
a
senior
counsel for
citizen.
petitioner principal is allowed a week's time to file supplementary affidavit stating therein that the respondent has willfully not complied the court order as he has not decided the representation of the petitioner. List after 1 week as fresh.
40, 13%.
Seniority list was done.
Yes.
Sir, you have not completed the order at all, sir. And moreover, after that, they have given a speaking order to me, which all the matters have been discussed in the CAT Bangalore and the High Court also, sir. They are just only
Come to the writ court order first.
Sir, page number 18, sir.
18.
And number 6.
You were the petitioner.
Yes, sir.
This is.
Always misleading the court and they are trying to run away from
Let us first let us understand what. Where is your? Who are you? Come to page 14. You are petitioner in this.
Yes, sir, I am the petitioner, sir.
Where is your name? You are respondent. Respondent.
No, sir, in the district petition is
And the writ petition or a,
petition, I am the district, sir.
in the writ petition.
I am the petitioner, sir.
Lord is asking you are a respondent in the writ petition, not a petitioner. In the contempt, you are a complainant.
Respondent, sir. You're right, sir.
Consider the representation.
Now, when did you file your objections? Where is that?
Sir, page number 20, sir. I have given the representation on 16/12/2021.
This is your objection.
Yes, sir, my objections and my representation telling that whatever has gone wrong.
Page
Page number 20, sir. Annexure C.
20.
20. Annexure C, sir.
It does not contain the endorsement, acknowledgement.
They have given the this thing, sir. Speaking order for the
Page 26.
Page 25.
This.
Is a presentation dated 16/12/2021. And dated first paragraph, paragraph 5. Provide order.
Now what they have done? Order?
We have just given a speaking order, sir. That is on 25 to 26.
Yes, your objections in compliance of writ court direction have been considered.
No, it is not considered, sir. These all, whatever they have given in the receipt, they have repeated the same thing which was already discussed in CAT Bangalore and in the High Court, sir. And they are only misleading the court, sir. Here they have taken a contention here.
Now this is a detailed speaking order. You will have to challenge it.
But court has never asked him.
Court has not said anything as to how they have to decide. What they have to decide, it was left to the discretion of the authority.
As per the law, they were supposed to decide, sir. And law is the gazette. They are not following the gazette at all, sir. I have been recruited as per the gazette, sir. And I am a direct deputy as per the.
In accordance with law. They were required to decide your representation in accordance with law.
No, they have not decided that, sir. Everything they have decided and already all the matters, whatever they have given, sir, has been discussed in CAT Bangalore and even in the High Court, sir.
Sir, if they are not considered in accordance with the challenge this order. Challenge this order.
This order would be quashed if it is not in accordance with law.
They have not replied to the court also, sir.
Contempt court has to see as to whether they have intentionally and willfully disobeyed or intentionally and willfully non-complied. We are not supposed to see as to whether they have rightly or wrongly decided.
They have not even completed the thing, sir, and they are not.
If you feel that it is not in accordance with law, then it will not amount to contempt. You will have to challenge this order. The court, writ court will see if it is not in accordance with law, then this order will go. It will be quashed.
But they have not completed the content also, no, sir. They have taken 3 months' time, and over that content was moved. After that also, they have not completed anything to the court also. They have only told.
What was the direction issued?
And they have finished it off.
Direction was issued to consider your objections
Yes,
in
sir.
accordance with law. They have already considered. They already considered in the past order.
So already whatever the matter was discussed in the CAT Bangalore and the judgment, and they have given in the judgment also. Whatever they have.
Correct,
discussed,
Hariprasad?
they have put.
Hariprasad, if you are aggrieved by this order, you file a writ petition.
That is all. We can give you liberty. Go and challenge this order before the writ court. It will not amount to contempt.
Already they have taken 3 years against.
Whatever it is, now this order is there.
32 years are not got even one promotion, sir. And as per the UPSC guidelines and this thing, Article 309 and 320 of the Constitution, I have been recruited. And here they have taken a contention here that
The scope of contempt is very limited.
But they have not completed at all, sir. They have not given any
Heard.
letter telling that.
We'll give you liberty. Heard? This contempt petition arises out of order dated such and such, passed in writ petition number such and such, whereby a direction was issued by the writ court to whereby liberty was given to the petitioner complainant to file his objections before the Director General Doordarshan within 2 weeks, and thereafter the respondent was required to finalize the seniority list strictly in accordance with law after deciding the objections preferred by the complainant and other employees. Para. as per the own case of the complainant, the respondent, wide order dated 23rd, 25. This is 23rd, 25th February 2022 has passed a speaking order whereby the objections preferred by the complainant have been considered. However, the contention of the party in person is that they have not decided the in seniority list in accordance with which, what document?
Sir, with the Gazette, sir.
Gazette
87 Gazette, sir.
1987.
Group A, Group B.
And
Sir, it is technical Group A and Group B, sir.
give the detail of that Gazette. Stop.
Sir, even till today, sir. Tell me the page number. 89, sir. Cameraman grade 2, 295 crores, sir. And it is a direct equipment, sir.
Gazette dated 5th of December 1987. Full stop. We have considered the submissions. We are satisfied that the order dated such and such, passed dated petition such and such has been substantially complied, as the respondent have passed a speaking order considering the objections preferred by the complainant. In case the complainant is not satisfied with the order dated 25th of February 2022, he is at liberty to challenge the same before the appropriate forum. However, it cannot be termed as a deliberate and willful disobedience or non-compliance of the order passed by the writ court. The contempt petition as such is dismissed.
They say that 52 posts and 70 posts they have not given it to anybody, sir.
Number
They say
15,
vacant.
Mr. Vijay Kumar.
Go and challenge that.
Thank you, sir.
Yes.
Complaints or because this on the
Where is that?
directions of this
Writ court order?
annexure here, page 12,
Page
relevant page at 18.
Page 18.
Paragraph number 18.
page 18.
18.
Yes.
Paragraph number 8 onwards.
Kindly read.
The state government, while posting officers to the posts that are lying vacant, shall also see to it that no junior officer is posted above a senior officer, leading to an ignominy of a senior working under a junior, which is the grievance in one of the connected petitions. Therefore, I deem it appropriate to issue the following directions as interim measure while keeping writ petitions pending consideration. Point 1. The state government shall notify the draft amendment to the cadre and recruitment rules within 2 months from the date of receipt of this order. All the stakeholders are at liberty to file their objections, if any, to the so notified draft rules. The state government shall consider the objections, if any, filed to the draft rules and notify final rules of amendment to the existing cadre and recruitment rules within 2 months thereafter. So far, they have not done any, they have not even published the draft rules. State government is permitted to make ad hoc arrangements during the apposite period till the finalization of the said rules within the time limit stipulated herein before for day-to-day administration in the posts that are vacant in both the cadres of chief officers grade 1 and 2. Even while making ad hoc arrangements, the state government shall not direct a senior officer to work under a junior officer. No employee who is posted in terms of the ad hoc arrangement that is permitted shall claim any right over the position that he is asked to hold as an ad hoc appointee. The state government shall place on record the final rules.
All right. How, in what manner the order has not been complied?
So point number 1, 2, and 3, my lords. Point number 1, 2, and 3. The direction was to publish the draft rules and call for objections to the draft rules, my lords. So far, my lords, they have not published the draft rules itself. For the direction to publish the same in 2 months. The order came to pass on 19/7/2021, my lord. And the petitioners, the complainants, my lords, have filed this contempt petition in the.
When did you communicate the order?
Yes, my lord. It is at page 16, not the next year, you have 23/8/2021.
Page
August 2021 itself. Page 16.
60.
Yes, sir.
Not filed translated?
No, my lord, I have not filed, my lord. I filed, my lord. Page number 61, my lord's last paragraph. Mary, my lord.
Please, my lord.
Yes, you have responded.
Please, my lord, I will take. Lord, draft rules are ready, my lord. It is today cabinet meeting is there. It is placed before the cabinet meeting, my lord. Another 15 days draft rules will be published, my lord. In fact, it is ready.
Thank you for the same.
Sorry.
This respondent number 1 will appear in person. Additional Chief Secretary.
But it will be done, my lord.
This contempt petition arises out of order dated such and such, whereby certain directions were issued to the state government to notify the draft amendment to the cadre and recruitment rules within 2 months from the date of receipt of copy of the order. The state government was also required to make ad hoc arrangements during the aforesaid period till the finalization of said rules within time limit stipulated therein in the order for day-to-day administration in the posts that are vacant in both the cadres of chief officers grade 1 and grade 2. Para. The order of the writ court was duly communicated to the respondents, learned AGA, appearing for the respondents, submits that the draft rules have been prepared and it is awaiting approval from the committee.
Cabinet.
Para. It is to be noted that the writ court had issued a positive direction to notify the draft rules within 2 months. Prima facie, it appears that the order passed by the writ court has not been complied till date. List, give a date next week. Monday.
6th June.
On that date, the respondent number 1 shall appear in person. He is person responsible.
Lord, both 1 and 2 both.
Respondent number 1 and 2 shall appear in person, so that अभी तो ड्राफ्ट रूल्स ही नहीं बने ना, वही तो लिखा है अभी ड्राफ्ट रूल नोटिस shall be proceeded further against them.
Item 16, I represent complainants in this matter.
Case number 2 is transferred and
Order compliant at Annex A, Milord.
not been office of the present is
Yes.
Milord, sir. Order compliant, Milord, at operative portion at page 16, Milord. The respondents, Milord, 3 and 4, who in the writ petition were directed to Milord, effect, Milord, the Podi Durast work, Milord, bifurcation of the lands. As per the, Milord, the decree that was passed by this honorable court.
Number 2 has been transferred. Notice has not been served.
The assistance, Milord, has received. But I'll find out, Milord, and take effective steps.
It is not served. You will have to move appropriate application for impleading the present incumbent on the post and take appropriate steps thereafter.
Please, I'll have it done.
As per office report, the respondent number 2 has been transferred and as such notice has not been served. Learned counsel for petitioner complainant may take appropriate steps giving correct present address of respondent number 2 he may take the steps within 1 week, may take the PF within 1 week in this regard. The petitioner counsel prays for is allowed 1 week, also allowed 1 week time to move appropriate application for impleading the present incumbent on the post of director, joint director, assistant director
of land records. Grateful.
Number 17.
Appearing for the petitioners now. I'm appearing for the petitioners now.
16A. Notice service 1.
Now, the operative portion of this order of this honorable court, my lord will find it page number 13. There is a direction to the respondent to provide basic amenities to the petitioner's sites within 6 months of passing of the order, my lord. Followed by this order, my lord, the petitioners have submitted a representation on 15th September 2021. My lord will find the English version on page number 16. No response was received by the respondent on my representation. I also followed up with another representation in the month of January. My lord will find it at page number 18. Apologies, my lord, page number 20. I have requested at least a borewell facility be provided because there is no drinking water facility to the sites. And I have been forced to take water supply from private operators, which I am from an economically weaker section. I'm not able to bear the cost, my lord. The BDA had undertaken to provide these
Come to
facilities.
relevant paragraph. Come to the relevant paragraph you have said, where you have
Please,
said
ma'am.
that the order has not been complied.
My lord, page number 13, paragraph number 5, my lord. Lord, may I read?
Eh?
On hearing the learned counsel for the
Paragraph?
parties, my lord,
We are asking where, in which your pleadings, where you have said that order has not been complied.
my lord, para number 8, my lord, page number 6.
Willfully failed to comply with the order for despite
Lord, I have submitted two representations after the Honorable Court has passed the order. It is submitted that the no action has been taken by the accused in this regard. The complainant number 2 once again addressed a letter dated 11/1/2022 requesting to at least provide a borewell in the area to meet the water requirements of the residents.
I'm appearing for accused. I'm appearing for accused. My lord, our request is we have filed a petition for review of this order, my lord. The judgment relied upon by the learned single judge, my lord, while passing the order. That also we have filed review. And the Honorable Court, at para number 5, page number 14, my lord, court has relied upon WP number 11129 of 2000. We have filed review against that order, my lord, because under section 53, my lord, we have issued direction in pertaining to Arkavati layout, my lord. We have issued direction to provide water. Their complaint is with regard to water supply.
What has happened to your review?
There is a stay against this order itself, my lord. And now BWSSP is made party and state government is.
This direction has been stayed.
Yes, my lord. This in WP number triple, which is relied upon by the learned single judge. The direction in WP at page number 14, my lord, internal page. The court has the learned single judge has relied upon WP number 1129 of 2000, my lord. This we have filed review in 303 of 2021. The Honorable Court has stayed that order because the state government, we have now BWSSP is requesting 340 crores from BDA, my lord, and we require the sanction from state government. Therefore, we have also brought to the notice that they have to be made parties, BWSSP and government. Therefore, the Honorable Court has stayed the matter, my lord.
Against this order also you have filed review.
We have filed review, my lord. Against this order also, we'll move the court in immediately.
Yes, petitioner counsel.
We have not received notice of the review petition.
On Saturday, we filed. We filed it day before yesterday, Saturday.
What?
A review petition we filed on Saturday, my lord. We'll get the matter before the court and get a suitable direction.
Yes. What do you say, petitioner?
My lord, may I request the matter be kept pending, my lord, because this is related to basic facilities to be provided by the BDA.
Do you admit that in review petition 1129/2022 stay has been granted?
My lord, the petitioners are not a party in that, so we are not aware. We are parties only in this writ petition, my lord.
Now against this order also they say that review has been filed.
We are yet to receive notice, my lord.
What happened? The counsel for respondent submits that they have preferred a review petition against the order dated 17th of August 2021, passed in writ petition 14501/2020 in bracket BDA, which has been filed on Saturday. Saturday का date देखते हैं. it is also submitted that the writ court has relied on the order dated 3/9/2020, passed in writ petition number 1129/2020. Against this order also, the respondent has filed a review petition 3020
303 of 2021.
303 of
2021.
2021, in which stay order has been passed. The counsel for respondent prays for is allowed 2 weeks time to file the counter affidavit, bringing on record all the relevant orders. Full stop. Placed after 1 month.
Obliged.
Number 18.
The office objection.
Rajgopala, there are certain office objections.
Number 4 also not served with notice. That is CEO, Town Municipal.
Office subject appears to be.
And the respondent has not been served also, respondent number 4.
Respondent number 4 may not be only a formal party. May not be.
But you have impleaded him, no notice has been issued. Chief Officer, Town Municipal Council.
Chief officer is made as a party because I'm the councillor for that municipality, therefore he made as a party. But dispute controversy is.
Notice have been issued, he has not been served.
Pro forma party is neither affected nor malad, sir. He is actually
Should not have been impleaded in contempt proceedings.
No, this is writ appeal.
Writ appeal.
Writ appeal.
Writ appeal, huh? Oh, sorry.
Calendar of events, there is a stay of disqualification. So we have suspended the election process after nominations were received.
The order of the learned finger, that is page number 19. Order of disqualification passed by the State Election Commission. As against the
The writ code is bad.
Then the disqualification order was confirmed by the learned single judge, by dismissing our requisition. There are three contentions we have raised before the learned single judge.
No.
Petitions submitted expenditure under section 6. So notice was issued to the election commission. But has not been
Similar matter, the petition was dismissed. But this has not been considered in this.
Bench of this court, Panindra, you are well aware.
Sadanand Gowda. More also is there. Another division bench judgment also takes the same view. There can't be any exceptions. And here they don't give any reason to the election commission.
That will not cover the controversy because it was basically on 16.6. 16.6 calculation.
It's a case where we don't give our explanations and accounts. It is not ready to the election officer, their officer, thereafter taken a decision. In our matter, we filed the explanation in the accounts. It was not given to the election commission. In a case where our affidavit found to be not correct in the election commission, our papers have not reached it there. Opinion required to be followed by the election. Not so, my lord. I can make it.
Do you have
what happened was, your lordship may kindly see.
do you have the order passed by the single judge in similar matter? Same controversy.
Controversy is arising out
Now,
of
writ petition has been dismissed. The writ appeal has been dismissed by the division bench.
petition was dismissed in that matter, where my lord election commission had an occasion to form an opinion. In our matter, our accounts and explanation have not reached to the election commission.
Doesn't make a difference. It will be covered by this. Controversy involved will be covered by this.
The notice issued by the election commission, we say give your
That my
explanation.
submission,
They don't give
that
any explanation.
issue is covered in my favor by virtue of 2014 SEC, where an identical provision and the representation to People's Act, Section 10.
Why we will go to representation of People's Act where specifically this provision has been upheld?
The language employed under Section 10 capital A.
We will not go to People's Representation Act when in this act itself this provision was challenged and
That's
the
what I would like to submit in this way. Please bear with me. Section 10 capital A of the RP Act, Section 16 A, B and C of the RP Act is one and the same.
if they had
What
not
were
been,
the one and the same?
if they had not been this judgment of the learned single judge in similar matter which had been upheld by the division bench in writ appeal, then we would have appreciated your contention on the basis of the Representation of People Act. But since this particular section itself was under consideration in similar matter,
which is relying upon
That it appears to be requires reconsideration like this. Please provide me an opportunity to address my argument. It requires reconsideration.
You challenge it.
On the language itself.
challenge before the apex court.
Well, it is not necessary. No law was declared there. It's a preliminary
We
judgment
cannot
apart
disagree
from-
with the division bench which has dismissed the writ appeal.
Well, your lordship, hear me. If the issue is covered in par with that, decide then. Otherwise, it has to take a different view.
It will be judicial.
I would be able to make out a case. It is not par with that. I could be able to make out a case.
Or the writ appeal is filed after calendar of events were issued. Process was on.
Well, it is-
That is, there is a constitutional bar.
That the
Judicial
petition was
propriety
disposed
doesn't
of.
permit us.
What?
Judicial propriety doesn't permit us to reconsider.
43 ZG. Even otherwise, my lords, there could not have been any interim order which comes in the way of the elections.
Well, on that also there is an issue required to be considered.
आपको समझा
Hear me and then.
No, there is no point, Mr.
Well, I could be able to make out a point.
We cannot. Judicial
That's a
propriety
different
doesn't.
aspect. If you are not, I'm not able to persuade, I will test my fate somewhere else. Now I wanted to put the contention. By that I would like to say that I could be able to convince. I have a point to argue, I will argue the matter. I can also argue that judgment has no application to me.
Please argue.
Yes. That your lordship may kindly make a note of these dates for a moment. But on 31/5/2019, results were declared. These petitioners are declared as elected from 3 wards in Anekal town municipality. Then on 27/1/2020, notice was issued by the State Election Commission. It was served upon me on 15/6/2020. Copies of the notice were annexed B, C, and D. Then on 17/6/2020, we have submitted our explanation along with the account as directed under notices annexed D, E, and F. Now, on 27/2020, returning officer informed the deputy commissioner in responding to the notice issued by the election commission, which is served through the returning officer, accounts have been filed by these petitioners. And it was sent to the deputy commissioner along with a covering letter. Then that was not reached to the office of the election commission. One fine morning, election commission said, we have issued a notice, no explanation, therefore we wanted to disqualify under section 16C. That we have challenged before this honorable court. Well, I lordship may kindly see the notices issued by the election commission, and next memo may kindly be seen translated copies are there. That we have filed a memo on 24/5/2022 along with documents.
Yes.
The first document is the notice annexed A, what the notice is to be. First paragraph may not be required. We kindly go to second paragraph. The Deputy Commissioner, Jandur Urban District, submit the report on 30/1/2020 to the Election Commission that you have not submitted the details of elections expenditure, thus you have failed to submit the accounts within time as described in law. Hence, this notice is issued as to why you have been disqualified under section 16C of the Act. It is directed to submit explanation in writing for having failed to submit the election accounts to the State Election Commission by extending 20 days time from the date of service of this notice to you. At the same time, it is also directed, may kindly make a note, at the same time, it is also directed to submit the full details of the election expenditure to the Tahsildar concerned. In the event if any reply is not received from you within the stipulated period, it is informed that Commission will initiate action as described under the above section 16, subsection C, class C of the Municipality Act. Well, our notice says we have not submitted the account. Notice calling upon us to submit the account and explanation. Time is given to us. If it is not submitted, proceedings will be initiated by the Election Commission for disqualification. This is the contents of the notice. Then your lordship may kindly go to our explanation for a moment. Sir, may kindly go to page 9, 17/6/2020. The notice was dated 27/1/2020, which was served us on 15/6/2020. We made a statement in the affidavit and the appeal also. On 17/6, within 2 days, we submitted our explanation. What is our explanation? Paragraph 2 at page 9, may kindly be seen Miller translation. May I read that?
Yes.
In this regard, I would like to bring to your perusal that at the time of election, I have submitted the Xerox copies of the details of day-to-day election expenditure without submitting the original copies in the prescribed format to the concerned returning officer, and I have not submitted the original copies. After I won in the election, I was busy in expressing my gratitude to the voters of the constituency in my ward, and I was in the contact of constituency about the problems of basic communities of that ward that was thinking about the process funds and also I was not having the knowledge to submit the original account of the election expenditure within time, hence the delay has been passed. Now I am enclosing here with the full details of the election expenditure to your good self. Ordinarily accept, etc. This is the explanation. Lord, may kindly see the order passed by the election commission for a moment. Before that, I would like to request your lordship to go to page 13, my lord. Letter of the returning officer to the deputy commissioner.
Page?
Page, my lord, 13 in my translation to memo.
Yes. Yes.
1-3. That is on 27/2020. With reference to the above subject, as directed in the letter cited as reference, notice has been issued to the column candidates out of the total 27 wards in connection with Town Municipal Council Anekal General Election 2019 from the office of the Under Secretary. State Election Commission, Bengaluru. 6 candidates have submitted the details of election expenditure. Details of election expenditure of the candidate is enclosed here with a submitted for your verification. Petitioner name is at serial number 1, serial number 4, and serial number 6. This is the Tahsildar acknowledges our accounts as directed by the notice. We have submitted accounts and explanation to the Tahsildar, who was the returning officer. Then my lord, may kindly go to the order of the election commission next page.
Yes.
Lord, references are made, section 16B and section 16C. Report of the Deputy Commissioner number 2, that is on 13/1/2020. Notices is 27/1/2020. Report of the Deputy Commissioner regarding service of notice and so on. Then, my lord, the preamble they refer. I would like to take your lordships to para 15, my lord. First, the last paragraph may kindly be seen. Last but one. Even though the notice of the commission served on a column candidates, as mentioned in the annexure, they have not submitted any explanation regarding failure of submit details of expenditure within the stipulated period. Well, that's a question which I would like to raise in the repetition we have raised is, our explanation is there and accounts is there. Election Commission says it is not there. That was the case where it was there. Then, my lord, in view of the above, 12 candidates mentioned in the enclosed annexure A failed to submit their expenditure, and also they have not submitted. The following order have been passed. In view of the facts as described in the preamble, it is confirmed that from out of the candidates who have contested from Anekal Town Municipal Council, Bengaluru, 12 candidates have not submitted explanation to the notice issued by the commission and also the details of the election expenditure. Hence, it is declared that candidate mentioned so and so are disqualified. There's a table is there at page 70. There are 12 candidates are there. Our 3 names are also there. After this, my lord, immediately these orders are communicated. Immediately after receipt of that, we submitted an explanation to the Honorable Deputy Commissioner on 3/2/2020, page 27.
Yes.
With reference to the subject, I say Srinivas is the member of ward number so and so. Anekal have carried out developmental works of the ward. Candidates are not submitted the details of election expenditure of the general election. Hence, notice came to be issued as etc. so and so. We have received the notice para 2. May kindly go to para 3, the last paragraph. Even though I have submitted the details of election expenditure as mentioned above. The order number so and so came to be passed, declaring me as a disqualified for a period of 3 years from the date of order passed under section 16C. On ground that I have not submitted the explanation to the notice issued to the commissioner and also details of election expenditure. Therefore, I being the member of the board have already submitted the full details of the election expenditure within the stipulated period. I earnestly request your good sir, kindly withdraw the above order, etc. This is our representation. Then the inquiry was initiated in the office of the deputy commissioner. Your Lordship, I kindly go to page 33. The Deputy Commissioner's office sent an information to the Election Commission. A mischief had taken place in their office in non-transmitting the our papers to the Election Commission. Therefore, an in-house inquiry was conducted. 2 officials are placed under suspension. That was referred to in Annexure U. May kindly be seen at page 33. Then page 34, may kindly be seen. Srinivas Lalita Lakshminarayana and Hemalata Suresh submitted representation on so and so, wherein have stated that they have already submitted the details of their election expenditure to the Tahsildar on 18/6. While perusing the Tahsildar Anekal Taluk submitted a report along with the details of the expenditure of the below mentioned candidate on 6/8/2020, our names are there. In this regard, may I kindly go to page 35. In this regard, Shokas notice came to be issued on 4/2/2022 to the concerned case workers, Sri Banu Prakash and Rohit Dive, informing them to furnish the explanation with regard to the non-submission of the report submitted by the Tahsildar Anekal Taluk, the Commissioner State Election Commission. They have submitted their explanation as under. Banu Prakash explanation is there. Then the Rohit explanation is also there. Then last paragraph may kindly be seen at page 36. In view of the explanations of the above mentioned case workers, by considering the fact that these 2 case workers, after receiving the report of the election expenditure submitted by the candidates within the stipulated time from the Topaz section, this office, without bringing to the same to the notice of the superior officer, without submitting the same to the election commission, seriously disciplinary action has been taken against them for their negligence, irresponsibility. They have been suspended from their duty. Details of election is submitted per enclosed here submitted to the perusal. This is the post facto order. In the background, what we have argued before the learners in this judges, an opinion is reported. It is the context in the light of section 16C. Some discretion is conferred upon the authority. Thus, explanation has to be placed before the authority. Authority is required to form an opinion. He has to form a satisfaction. If not, he has to proceed with the order. Here is a case, our expenditure and explanation is there. It was not considered by the election of commissioner as it was not there. But unfortunately, learners in the state forms an opinion. I am not happy with it. Well, it is not for the learners single judge to say, forming an opinion by your lordship under Article 226, forming an opinion by the executive authority is totally different. This is precisely the argument we have advanced. How it is held by the learners single judge, they can see the order not for a moment.
been stated that in case if they have not submitted a detail.
It is only, there are two things to it. That's how the election commission follows. One is, my lords, delay. We only say give it so that, my lords, we collect it and keep it. It's not that we are giving an opportunity because the act does not even provide. That's the law.
But in a show cause notice.
Yes, my lords.
If he has not submitted, if the candidate has not submitted
accounts,
then he has been directed to submit the
Submit it
accounts
to the
within 20
Tahsildar.
days.
Yes.
Okay, as per the report of the Tahsildar, they have already submitted.
That is submitted pursuant to that, they say. Lords, there are two. Yes.
Letter dated 20th/7/2020.
Yes.
With annexed G.
Yes.
Tahsildar has submitted a report to the Deputy Commissioner, wherein in the said report it has been stated that they have already submitted the election expenditures.
On 20/07/2020, my lords, the case is, my lords, what happens is the Tahsildar says, I have intimated the Deputy Commissioner.
Correct, even Deputy Commissioner also says.
Now he says there has been some misplacement of file, nobody had put up. My lord, there are two things here, my lords.
Correct, for that they should not.
No, there are two things.
How he can be.
Yes, I understand. But now please see the act section, my lords. How the section words.
16C.
16, my lords. Lords,
May just give me
there are two parts to the section. The section does not permit the filing of accounts to be condoned. Please see the section for a moment. It's a 16B of the Municipalities Act. Section 16C, Your Lordship. 16B is lodging. He says, I will only, my lords, consider if he has filed, I will consider whether there is a reason to condone the delay, whether there was justifiable reasons if they had not filed the accounts. Now, my lords, we give a notice saying that you have not done it within 30 days. So they should have filed it within 30 days or maybe.
Correct. If you have stopped there, then could have been different. But again, you have said
you
it is also directed to submit.
Please, my lords, there are two things. That's what we said. Give an explanation to me. And also, you file your accounts with the Tahsildar. Lords, that is only to ensure some transparency if there is. But for that, my lords, they could have given a reply to us. They don't even give a reply. Raj Act, Lords, for Panchayats, there is section 308. There also it fell for consideration. Lords, the question is, if he files beyond the time, whether I have the power to condone.
Correct, but in
I
your
only
show
say
cause
you
notice itself, in your show cause notice
Yes,
itself.
Lords, that was not necessary, but he did not even give a reply to me. Lords, in the notice I said, give a reply to me. He does not even give a reply to me. Please see, Lords, what the notice says. You give an explanation as to why you have not filed your accounts within the stipulated time. That's the notice given.
Correct, this notice was issued by the Tahsildar, who
No,
was
no.
the returning officer.
No, my lord,
By the
no,
Election
no.
Commission.
Election Commission. It's issued by the Election Commission.
Directed me to file the return before the returning officer.
My lords, there are two parts to it. My lords, please see the notice, which is issued by the Election Commission on 17/6/2020, my lords. The translated copy, your lordship. Accounts to the Tahsildar, but explanation to me. He does not even give an explanation to me. But the notice, if your lordship sees the Kannada version also, is very clear. There are two parts to the notice. One is file the accounts to the Tahsildar, one is give an explanation to me. No, he does not even give any explanation to me. Now what can I do? I only rely on the.
Correct, but Tahsildar has already submitted a report.
Yes, yes, that is beyond time. But then the question is whether, my lords, even then it is beyond time. Then lords, even then, I'll have to exercise. If my lords, if then, my lords, I'll have to see whether there is any possible cause to condone the delay. That's as per section 16C. There was nothing before me. My lords, if he had given one letter to the election commission saying this is the reason why we had not submitted, I would have exercised that jurisdiction. When I don't get a reply, I have nothing else to do. Says I was ignorant. One is I was meeting the voters after my victory. The learned single judge goes and considers and says this is not even a possible cause to condone the delay. And here, my lord, by the time the writ appeal was filed, the calendar was already in motion. That is the only. Beyond that,
Election has been set on motion.
it was, my lord, the second of calendar was in motion. (243) ZG minutes. It's parameter to 329 minutes. 243 ZG.
That G is only with respect to
Constitution. Any election, my lord, is a constitutional bar. That is how it is considered.
delimitation.
A is, my lord's, delimitation. B comes, my lord's, no election to municipality. B.
No election of any.
To municipality shall be called in question except by way of an election petition. Now, my lords, the question is, once there is a bar, this is, my lords, parameter to 329, Article 329. In respect of assembly and parliamentary elections, my lords. It is the same thing so far as municipalities are. That has been interpreted to mean once process has commenced, there should be a hands-off approach. That's the judgments of the Honorable Supreme Court on several matters. I have the citations, my lords, I can pass it on.
This writ appeal has been filed
After, my lords, the Election Commission announced the schedule of elections on 28th April. Calendar of events were to start on 2nd of May. 2nd of May, it was notified by the Deputy Commissioner without receiving nomination papers because 2nd of May was a holiday, declared a holiday subsequently because of Ramzan. But the process started. 4th of May, they filed their writ appeal. By 4th of May, the process had admittedly commenced. And their own writ appeal, they say it has commenced. Now, this order, now, my lords, indirectly affects the elections. I may also submit, my lords, on the same day, there were 3 writ petitions filed by individuals challenging our calendar of events before the learned single judge on some other technical ground that 7 days time is not given. Notice was issued to the Election Commission, we appeared same election. We said the process has commenced, there was no stay granted. But this, my lords, was in a writ appeal.
Is this. Your Lordship may kindly see the date of the order of the learned single judge. if there is no due diligence or honesty or bona fide not on my part, then it would be. What best a ordinary person could do, we have done so far as challenging the order of the learned single judge. We can narrate on the fact. Then I will go to the law also. Supreme Court in 3 occasions said, including the coordinate bench of this honorable court, where a vacancy is concerned, vacancy is occurred due to some disqualification. If a dispute is pending, that vacancy cannot be construed as a vacancy unless and until vacancy is sustained by the High Court. That was the law, 1967 Supreme Court, Sanjeev Rao's case. Then, my lord.
Whatever it is now, after the issuance of.
No, I will submit. Why, my lord? What best I can do for this? Date of the order of the learned single judge, 18th April 2022. Take ID me.
Yes.
We filed an application for certified copy on 19/4/2022. Certified copy was delivered on 22/4/2022.
It was prepared and examined on 22.
Yes, on that day, after the examination and preparation, certified copy was delivered on 20th. Then on the very next day, last vacation in that week was the Friday. On that day, copy was not there. Then Friday evening, when we copy received, immediately we preferred the writ appeal. We approached the residence office of the division bench senior judge.
You can't do.
But hear me. I want to, I cannot say that if your lordship say can't do, I cannot insist doing. But here as I can make out a case, still I go.
What else we are doing?
My lord, your lordship may kindly see copy was delivered.
We have seen
Vacation
it.
was there. I approached the very next day, even before issuance of the election notification. Learned senior just said, no urgency, let it be on Tuesday. 5 o'clock on Tuesday, a special bench was constituted and interim order is granted.
All right.
Whereas that was not the notification. What my learned friend referred to is, your lordship may kindly go to page 101. Calendar of events was not there on that day. They are making an incorrect statement on record. But lordship may kindly see 101 for a moment. Page 41 of my translations may kindly be seen. This is the notification issued by the Election Commission informing the district election officer, deputy commissioner to issue notification of calendar of events. What is the shape of calendar of events have been intimated by the Election Commission. It was not the notification by the calendar of events. May kindly see me at page 41. In exercise of the power conferred under Article 243 of the Constitution and Section 17 of the Karnataka so and so, the State Election Commission hereby ordered to conduct general elections to one urban local bodies as mentioned so and so, and also to conduct by-elections for the post-fall vacant for various reasons in urban local bodies as mentioned in so and so at this order as per 24 of the Karnataka Town Municipalities Act, Karnataka so and so. Then election timetable. Date and day of issuance of election notification by the Deputy Commissioner is 2/5/2022. We have filed the writ petition on 34/2022.
4th May you have filed a report.
4th May, my lord, we went to the senior judge of the vacation court.
Correct.
In the residence of his office.
Read page number 42.
Yes.
Code of conduct will be enforced from 2/5/2022.
It's a code of conduct, it is not that. Calendar of events commences from the date of the calendar of events notified by the district election officer, who is the authority under the Municipalities Act to issue calendar of events. Election Commission is only supervising the things. Therefore, it is instructed the Deputy Commissioner, you should issue calendar of events. That calendar of events indicates the date of events as follows. Thereafter, on second day, notification was issued by the Deputy Commissioner. This was not the notification calendar of events. Calendar of events is commencing from 2nd of May. Before 3 days earlier, I went to the senior judge of the vacation court. He was not in headquarters. I went to the home.
When it has been filed.
Post where vacancy is occurred. Vacancy is occurred because of passing an order under section 16C. 16C order is under challenge in the writ petition as well as in the writ appeal now. What is the effect of pendency of the dispute so far as vacancy is concerned? Whether put it mandate to go ahead with the by-elections is a question. This was considered by the Supreme Court in 1967 in Sanjeeva Rao's case, where it is arising out of the order passed by this honorable court. Secondly, in 2011, from Andhra Pradesh, very situation was examined. Ultimately, the Supreme Court answered, in the event an election dispute succeeded by so and so, by that time by-elections have taken place. Can there be a two representative for one constituency was the question considered by the Supreme Court. So suppose if I succeeded here, if your lordship is kind enough to show my rescue in my favor, this order is error. If it is set aside, then my councillorship will restore. What is the fate of the new incumbent by virtue of an election taken place by pendency of the list? This is precisely the point considered by the Supreme Court as well as the coordinate bench of our Honorable High Court. I have the judgment ballot like to pass on it. To the office of a MLA that has to be filled up within 6 months. Whether that holds field in a case where election disputes are pending.
The order.
Can I refer to the judgments not for a
No need, because we are not satisfied. In view of ZG, we are satisfied that one
That I am
election.
here to pursue to make your lordship
We have heard
satisfied
you
on the
enough.
legal issues.
We have heard you at a length and we are not satisfied. We'll pass the order.
May I pass on this judgment 2020
We'll pass
also.
the order today itself.
May judgment.
You give it whatever you want. Because
Paragraph 15 to 19, my lord, very relevant. May kindly refer to, my lord, these arguments, including citations which I cited in the course of my argument. At least for that favor may kindly be extended to me.
all right.
Number 19, Girish MK. Annexure B, please, my lord. Annexure B is a copy of the lease deed, my lord.
By way of amendment, my lord, subsequent to my lord's pendency of the petition, they have filed the amendment petition, my lords. I need to file objection for that and required. As far as main matter is concerned, I have filed objection. But amended, my lords, seeking extension of the lease, my lords, that objection I have not filed.
Amendment has been allowed.
Amendment is allowed. Allowed, my lords.
Now you want to file the objection to the
Amended petition also. Subsequently, new place prayer is added.
3 weeks time to file the objection, statement of objection to the amended petition. List there.
Great.
20.
Lordship, I appeal for the petitioner in this case.
I appeal for the 16th respondent, Lordship.
For 7th respondent in this matter.
Lordship, on the last, the matter was supposed to have been taken up for final disposal today. But Lordship, the state government has not served their statement of objections on me. I have just got an additional statement of objections.
Whether physical amendment has been carried out?
Yes, Lordship. Amendments have been carried out. Office objections from the petitioner side have been carried out. Without objection, statement cannot proceed, Lordship.
Statement of objection है amended petition. It is here. It is amended petition.
I have not been served a copy, Lordship.
The copy of additional statement of objection may be provided to the learned counsel for petitioner.
Lordship, additional statement is provided. The actual objection statement is not given to me. The main objection statement.
Instead of additional, say main objection. List in the month of July.
Obliged, Lordship.
Move for retirement. Move for retirement by Mr. Bhaiya.
That may be allowed. Move for retirement or moved by is allowed. Office is directed not to print the name of so and so.
Request. So far as an advocate for respond number 6 is concerned, the CS Kanu's name is shown, not maybe directed to be deleted. For number 6 advocate.
It is the name of counsel for respondent number 6 shall be mentioned as
Lord Murugesh P. Charati only. Lord,
in place of Mr. Kannu.
Number 21. Arun Kumar, entry 14%. Lords, in this case, objections are ready, my lords. In 2 days, I will file it after serving.
Learned AGA place for is allowed for weeks time to file the statement of objection. List thereafter.
So can I make a presentation? What they
They
for the
will-
last 50 days, it's quite good time, sir. I don't know what they have done in this case.
Thank you. Number 22.
For 2 weeks time, we again the service of the senior counsel. I will not ask you.
Again on the request of counsel for petitioner. List in the month of July.
In this matter, I had sought some time, in the question of maintainability. Over it appeal at the hands of
The preliminary notification was issued in the year 2003. Till today, they are not issued.
Yes.
But I have made a compilation of the authority, which go to show us that the Supreme Court has taken a view that even in the preliminary notification stage, the beneficiary may be heard for different reasons. may I also say on facts? That before the learned single judge, when the writ was originally filed, I was not made a party. And it appears, my lord, that an order was made to impede me, which order has not been challenged by the petitioner landowner. So to that extent, my lord, in the facts of this case, that question of whether I am interested or not appears to have been settled, my lord, before learned single judge. And he, my lord, amended the petition to make me a party. On facts, my lord. Because insofar as the law is concerned, if your lordship will kindly take the judgment at page 1, where the issue is directly addressed. This is in 1994 SCC 74. Lords, it's a short judgment. Lords, where the question came up whether the beneficiary could be heard, where in the writ petition challenging the section 4 notification, the beneficiary was not made a party, and thereafter sought impediment. After being impeded, when the beneficiary sought to file reviews against an adverse order, in 2 review petitions, a view was taken that the beneficiary was not an interested party. In that context, may I read paragraph 2 of the judgment? It is contended by Mr. So-and-so, Senior Counsel, that there is a conflict of decisions as regards same matters that 2 review petitions and business relating to other claimants. Putting that corporation in that case was beneficiary, was not a necessary party. In other words, it was not an interested party, and review petition in the impugned order was allowed by implication that corporation was an interested party. It was also further contended that on the question of locus standi of the beneficiary to be included as a party, there is a conflict of decisions of this court in so-and-so versus so-and-so and Himalaya Tiles and Marble Private Limited. And when this conflict was brought to the notice of another bench, that bench has distinguished decision in Ahmedabad Municipal Corporation case, and that therefore conflict still subsists and requires to be resolved. We will not find force.
Land will rest on the government for section 28 for notification.
The facing page.
Section 28 is very clear. Land will rest in the government only and if a notification.
But section 4 is akin to 28(1).
Different हो जाए.
The repetition.
May I only place the last portion of this paragraph, which is on the facing page.
Ask him. Since you ask him,
You are a party to.
Lord, I was made a party by impediment at the instance of the learned single judge.
Not only that, you have also been heard. But the learned
I did file my statement of objection.
Correct. Put a sought for come to para 2 of the impugned order, page 21.
Third learned counsel for petitioner, learned HCGP for respondent 1.
And learned counsel for respondent number 4.
Please,
You already addressed the argument before the court. You already addressed your argument.
Because on the last day, your lordship asked me whether I was entitled and had the locus to file this.
Correct. Now,
yes. What prejudice has been caused to you now?
But the prejudice that is caused to me is this, your lordship's court and honorable Supreme Court have held that an extent of 20,193 acres of land is required for this project. It issued a mandamus to the state to complete the acquisition. It is my express case that this parcel of land, which is held by virtue of this impugned judgment to be lapsed, acquisition of which is held to be lapsed, is part of the 20,193 acres. I have also stated before the learned single judge that there are parcels of land around this land, constituting it into an island.
We can give liberty in case the order is passed under section 28(3), 28(4). Only thereafter you will have the right to challenge this.
In fact, the honorable Supreme Court says.
Right now, no prejudice.
If my lord will kindly see the judgments of honorable Supreme Court which are placed by way of this memo.
We will reserve your liberty in case the state government has passed the order under section 28, subsection 4. Then you will have this liberty to challenge this order.
But by virtue of the impugned order, since the 28(1) itself is quashed, the question of proceeding to 28(4) would not arise unless your lordships were to interfere and reverse the
correct. When a preliminary notification was issued?
In 2003.
3.
Please.
You have submitted a representation in the year 2006.
Lord, thereafter, Lord, in fact, Lord, as late as 2011, the place in this compilation was
Not 28.
Honorable Supreme Court has expressly directed that the entire extent of land should be acquired and nothing should be released from acquisition.
2003 itself, you have submitted a representation to issue notification. Doesn't get a right.
May I only point out that there are two sets of mandamus issued by your Lordship's Court, affirmed by Honorable Supreme Court, and an express direction not to release the land, issued in 2011
The state government could have challenged this order.
Lord, respectfully, Lord, may I take your Lordship's
But you do not have any right. State government is not challenging it.
Lord, may I take your Lordship? The authorities are placed today. Lord, your
They could have challenged
it,
this order that we have not abandoned it and still we are pursuing it and we will pass the order 28-4.
That's the entire difficulty. I'll show your Lordships from the judicial record that state is willfully, Lord, disobeying the orders to complete the acquisition. The genesis of this matter, Lord, is that there is an agreement between state and me to acquire 20,193 acres of land. Lord, Honorable High Court has noted that after defending that acquisition in writ appeal, the state withdrew from it. Express mandamus was issued to them.
Challenge this order.
At Millards, in 2021, this is not only one matter, Millards. There are hundreds of writ petitions are filed and they are.
What are you going to do with it? If you don't want to pursue it, withdraw it.
Millards, the state is not Millards and taken any decision for filing Millards appeal in this matter.
Millards, may I
that is my
point-
instruction.
Why you are keeping it pending when after issuing 28-1, you are not doing anything?
In respect of some of the extents, Millards, they are not issuing the final notice.
Lord, can I request your Lordships to
There is a very dispute, Millards, very
Millards,
dispute, Millards, entitlement of the Millards beneficiary before my. What extent he is entitled, Millards, under the scheme? What he has.
That is one issue.
Yes.
But the thing is that if you have issued this 28-1 in public interest,
Yes.
then why you are keeping it pending? Why you are not proceeding further? Why? And he says that some orders have been passed.
First, those orders, what he is referring, may not be pertaining to this particular subject matter of the land. Those are related to some general orders.
May not be with respect to this particular
Yes.
land,
Yes.
but it is with respect to the entire project.
This entire project consists of different Millards portions. It is
So
not
we
that
would
much.
like to know why, what is the stand of the state government in
Yes,
such a
Millards.
matter?
I'll secure Millards.
Lord, the reason they do not withdraw, Lord, is because at page 102 of this compilation, the Honorable Supreme Court has expressly
By
stated
change
that
of government or by change of interest, you cannot abandon the projects which have been done in the public interest. You have to clarify your stand.
Yes.
You clarify it, what
Please.
you want.
Very well.
We may not entertain this petition on his behalf.
Yes.
But it is the state government who has to.
Come with clean Millards to say whether they wanted to continue or not.
May I, Lord, so far as your Lordship's observation regarding my locus is concerned, may I only point out two further observations of Honorable Supreme Court, including in a constitution bench, saying that, my lords, I have the right to appear before your Lordships, including in appeal, to defend my intended title in the
You have been heard. You have been heard in the writ court. Therefore, all those pleas are not available to you in writ appeal.
Lord,
If you had not been a party, then the matter would have been different. But you were made party, you were heard, your submissions were taken into consideration. Now,
Lords, and to that extent, Lords, to the extent that the learned single judge in my respectful submission wrongly says that the acquisition has lapsed, I would respectfully submit to my lords that I am entitled, my lords, to place before your
you
lordships.
were only
that that
entitled to
finding
be
is-
heard, that is all.
Lords, would your lordships kindly see two observations?
All right, we
Please, my lords, I
ask them to clarify their stand.
Yes.
very well.
This intra-court appeal has been filed, challenging the order dated 21st of June 2021, whereby the writ petition preferred by respondent.
Respondent Lords, 1 to 4, my lords.
1 to 4 was allowed, and the preliminary notification dated 29 January 2003 issued by KIADB under section 28(1) KIAD Act was paused so far as it relates to property of the respondent number 4 at survey number 21, measuring 4 acres, situated at Varahansandra village, Vidyapita Post, Kenderi, Hubli, Bengaluru. Learner Council for Appellant submits that due to the impugned order, he is prejudiced. First off, it is submitted that the entire land consisting of
20,193 acres in all.
20,193 acre was marked for the project.
Bangalore-Mysore Infrastructure Corridor Project.
And for that, the preliminary notification dated 29/1/2023 was issued. However, the state government thereafter has not proceeded further. It is submitted that the writ appeal on behalf of the appellant is maintainable. Apart from the question with respect to the maintainability of this writ appeal on behalf of the appellant, we would like to know the stand of the state government as to whether the state government is still ready to proceed with respect to the notification, preliminary notification dated 29/1/2003 issued by KIADB under section 28(1) KIAD Act, and why the state government don't write why, and what is the stand of the state government with respect to the impugned order.
You filed a statement of objection in the.
Please, we
You
have
submitted. You have not filed a statement of objection.
I'm sorry, my lord, it is produced along with my writ appeal.
You have submitted that you have not filed a
No,
statement.
my lord, I'm sorry. I think I made a miscommunication. But I did file statement.
Well,
and I
we have not
produced it.
recorded. We have to just give a date after 2 weeks. We'll consider the maintainability part also. You keep this judgment right now.
21/6.
I'm sorry, my lord. It is an error on my part. May I again reiterate my submission that I hold there is a special counsel for state appearing in the PMICP project.
Yes, miss, I do
Yes, your lordships are pleased to direct him also to appear, my lord.
Yes, I'll inform him. See, appears, but I'm here, my lords, I have taken notice. He will, my lords, will make an internal arrangement for Gautam Bharadwaj case, I live for.
24, PAK Vasan.
My lord, appearing for the petitioner in this case, my lord, I pray for a week time, my lord, to seek instructions from the petitioner, my lord.
I am appearing for the respondent 4 below.
I'm appearing for the petitioner, my lord.
17
Asking for adjournment, adjourn on the request of counsel for petitioner to complete his instructions. List in the month of July.
Please.
25. In Keshav Reddy.
Lord, I appear for
the
petitioners.
respondent number 1 in
Lord, the respondent number 7 has served a copy of the counter affidavit today and now, just half an hour back. I pray for a small accommodation so that I'll go through it and then make my submission.
Memo dated 28/6/2021 for transferring the writ petition to National Green Tribunal.
My Lord, that
You have find
application, my Lord, that application, my Lord, senior advocate, my Lord, Naganand had made a submission before this, that we are not pressing that application for transferring the case to NGA. Because today, my Lord, he has not appeared because just now I have been served with this copy. Next, my Lord, next any date convenient to this honorable
Do you press this memo or
No, not pressing.
you want a transfer of writ petition to National
Our memo, that memo, my Lord, senior advocate had made a submission before that we are not going to press that.
So you are not going to press this
We don't
memo?
want to press and we have to continue here.
Let counsel for the petitioner submit that you not press memo dated 28/6/2021. Submission is placed on record. Memo is dismissed as not pressed.
But any short accommodation, because just now I have been served with the counter affidavit.
All right,
By the respondent number 7, my Lord.
List in the month of July.
Please.
Number 26.
Here was petition counsel, my lord. This is, my lord, allotment by releases to the section of the rule 3F. But
All this will come in July. List in July. List in the month of July. Give it date in July, second week.
Application. Number 27.
Extension.
Give a date, list along with. list
27, I represent respondent 3 to 5, my lord.
All
My
right.
lord, I appear for respondent number 7, 20 and 21, my lord, in serial number 7.
We are fixing a date. This application will be considered on the next date when it will come along with the record.
Very well.
Very well, my lord.
7.
7. Next.
Name is
Obliged, my lord. Grateful.
Obliged.
Venkatesh S. Arbati. Name should be shown on the.
Number 28.
Lords, I appear for response 5 and 6.
Petitioner.
July.
12/7.
Grateful.
PIA disposed of.
PIL rules also to be
You have to comply the PIA rules also. In the meantime, the counsel for petitioner shall ensure the compliance of PIA rules.
29. AP Bhatta.
Amendment. Give a date. The IA sections list on itna, the IA 1 of 2022 shall be placed on record. It shall be considered on the next date.